Hello, this is Annabelle Gabberty from the law firm Crefovi. Nice to see you again. And I think it is time now to start our live webinar on arbitration in France and the UK, who has the upper hand. So in the aftermath of Brexit, which has made the enforcement of civil and commercial courts judgments from the European Union, from the EU, in particular from France, to the United Kingdom, and vice versa, much more difficult and opaque, the option to resolve disputes by way of arbitration has become much more appealing. Indeed, as explained in various of our articles published on our publication section of our websites, crefovi.com and crefovi.fr, which are restricted content. So if you want to have access to these articles, you now need to purchase a subscription of for an annual fee. And you can do this through our stores, which are crefovi.com/store and also crefovi.fr/magasin for the French version of these articles. So so as explained in those various articles, in particular, alternative dispute resolution in the creative industries, which we published a few years ago, arbitral awards are recognized and enforced by the Convention on the Recognition and Enforcement of Foreign Arbitration Awards from 1958, which is called the New York Convention. And both the UK and France are parties to the New York Convention, and therefore such New York Convention remains unaffected by Brexit and non-impacted by the effects of Brexit. So, for example, this week I had another lawyer from the French, from the Paris bar, who contacted me and said, "Okay, well, I need this French decision, this French order to be enforced in London, in the UK." I said, "Great, fine, but we first need to actually do an analysis to check which enforcement regime is going to apply to this order." Because now there are three regimes. There's the pre-1st of January 2021 regime, which is basically the enforcement via the Brussels I regulation. Or there's also the transitory regime, which applies for EU decisions, which were basically which legal proceedings were started before the 1st of January 2021, but which were then eventually handed down by the EU courts, in particular the French courts, after the 1st of January 2021. So this is the transitory regime. And then there is a post-Brexit regime for basically court decisions, which were handed down after the 1st of January 2021. And this is where it's completely opaque and unclear. So I ask you to have a look at what we set out also in our other article called How to Enforce Your Civil and Commercial Judgments After Brexit. And you will see that it is a very opaque system indeed for these, for all court decisions which were handed down after the 1st of January 2021. So in view of that, of course, arbitration is definitely on the rise, because arbitral awards can be enforced through the New York Convention, which is non-impacted by Brexit. And a lot more trade agreements are now contain now an arbitration clause, okay, to have all disputes resolved by arbitration. But how do you do that in practice? I mean, which seat do you choose for your arbitration? Where is it the best place actually to locate your arbitration? In London, in Paris? So this is what we're going to discuss today. So so it's now easier to enforce arbitral awards from France to the UK and vice versa than to enforce civil and commercial court judgments from France to the UK and vice versa. So who has the upper hand between France and the UK in terms of key features of each country in their respective arbitration systems. In other words, which jurisdiction is best to resolve disputes by way of arbitration? Well, so there are quite a few arbitration institutions in both countries, and of course, it's both capitals which are the main seats of arbitrations, i.e. Paris in France and London in the UK, obviously. These are not really regional forums. It's usually done in the capital. So for France, there's the established, very long time established arbitration institution called the International Chamber of Commerce, which was founded in 1923 in Paris by a Frenchman called Étienne Clémentel, who was the first president of the ICC. And then other arbitrations set up shop in Paris, such as the Centre de Médiation et d'Arbitrage de Paris, the CMAP, founded in 1995 by the Chambre de Commerce et d'Industrie de Paris. Then there's the Association Française d'Arbitrage, as well as the, which is not really I don't think that they have a lot of arbitration matters, the Association Française d'Arbitrage. I'd say it's more like a network of arbitrators, to be fairly honest. But, you know, on paper, they say that they are actually an arbitration institution as well. Then you also have the Chambre Arbitrale Internationale de Paris, and the also Chambre Arbitrale Maritime de Paris for maritime law matters, and sea law matters. And also you have the new kid on the block, Delos Dispute Resolution, which seems to be, you know, a very forward-thinking arbitration center. Its website is in English, so that's delos.com, I think, and it seems to be very on the ball. In the UK, it's worth noticing actually that the UK had adopted arbitration even before 1923, because the London Court of International Arbitration, the LCIA, was actually incorporated in 1892. So it's quite a while ago. And it's actually not long after the UK's 1889 Arbitration Act became law. So the UK has really been a very early adopter of arbitration. Then there's also the UK offshoot of JAMS International, which is a US arbitration institution founded in 1979 in California. And there's also CEDAR, the Center for Effective Dispute Resolution, as well as the London Chamber of Arbitration and Mediation, which is part of the London Chamber of Commerce, LCAM it's called. And there's also Falcon Chambers Arbitration, which is a group of specialty property arbitrators from Falcon Chambers, and also Sports Resolution, which is a London-based dispute resolution institution for sports, founded in 1997. So as you can see, both Paris and London have got either general arbitration centers, such as LCIA, ICC, but also very granular, very specialized arbitration centers, such as the Paris Court of Maritime Arbitration, or the Falcon Chambers Arbitration for property matters, and also Sports Resolution for sports matters. And so there are quite a few facilities as well that can be found in the center of Paris and London, where you can actually hold your arbitration hearings and meetings if you don't want to do them online. Okay, so I won't go too much in these sort of very pragmatic matters, but as you can see, Paris and London are really super well geared towards arbitration. So on this sort of, institutions set up in both capitals, both of them are very strong. So there's no winner in there. Both of them are very strong. Now, in terms of the key features of the French and UK arbitration frameworks, well, let's have a look at the legal framework. So most of the rules applicable to arbitration are set up in the French Code of Civil Procedure, the CPC, Code of Civil Procedure, Code de Procédure Civile in French. So the French arbitration law distinguishes between rules applicable to domestic and international arbitration. So domestic are arbitrations where both parties are based in the same country, so two French parties, for example, two English parties. As well, international arbitration contains a cross-border element where one party is from one country and the other party is from another country. And so French law distinguishes between domestic and international arbitrations, and there are certain provisions which only apply to domestic, while others apply to both domestic and international. And this distinction matters actually because the rules applicable to international arbitrations are more liberal. Okay, so with regards to both domestic and international arbitration, France created a dedicated judge, un juge d'appui, who has jurisdiction over arbitration-related issues and who acts in support of arbitral proceedings. So such judge may assist the parties in the constitution of the arbitral tribunal if any problem arises, especially in ad hoc proceedings, as the judge's role is limited in proceedings governed by institutional rules. Okay, so the judge will only the judge basically has a limited remit, and it's mostly when these arbitral proceedings are not governed by the rules of an institution, an arbitral institution, that this judge may intervene in relation to, for example, an issue on the constitution of the arbitral tribunal. So in addition, the Paris Court of Appeal recently created a dedicated international chamber exclusively focused on appeals against first instance decisions in cross-border commercial matters and some other specific matters such as the annulment proceedings against international arbitration awards handed down in Paris, as well as challenges against enforcement orders in order to ensure coherent case law. So similarly, the French Cour de Cassation, which is the French Supreme Court, systematically assigns such proceedings to its first civil division. In the UK, meanwhile, the current Arbitration Act, which is the Arbitration Act 1996, the Act, regulates arbitrations seated in England, Wales, as well as Northern Ireland. The Act is currently being reviewed by the Law Commission, which published its first consultation paper in September 2022, a 153 pages long document, to ensure that the Act remains best in class. So in this report, it is suggested that reforms relating to confidentiality, discrimination, arbitrators' duty of disclosure, arbitrators' immunity, and other changes and clarifications should be envisaged in the near future to make London an even more secure and efficient seat for arbitration. So applications in support of arbitrations are made in the specialized courts in England and Wales of the Business and Property Courts of the High Court of Justice, so typically in the Commercial Court or in the Technology and Construction Court. And these courts consist of judges who are suitably experienced in arbitration and commercial matters. So as you can see, in terms of a legal framework in both jurisdictions, and also so in Paris and London, we have also a really quite well set up and established framework here. So there is no apparent winner here again. So in terms of the second key feature, the distinction between civil law and common law. So obviously Paris and France is a civil law system with a civil law code, as I'm sure you know. And many arbitrations, though, sitting in Paris are subject to foreign laws, such as English law or Swiss law. And some arbitral practitioners, including arbitrators, are familiar with general common law concepts. Having said that, though, I really do think that it would be really quite stupid to choose Paris as the seat for an arbitration which relates to a common law type of governing law, such as English law, US law, etc. If you have English law, it would make more sense to actually have the arbitration seated in England in a common law system. Having said that, though, it's important to note that France, despite the fact that it's a civil law system, does have some capacity to host arbitrations in relation to English law or some US law systems. Of course, the UK is a common law system. So both France and the UK are parties to the New York Convention, as I mentioned before, as well as to the ICSID Convention, which entered into force in 1966. So what is the ICSID Convention? Very quickly, it is the it's a treaty ratified by 157 contracting states, and it relates to disputes between states and other parties, and it's in relation to investments. So do look into this if you want to know more about it. In any case, both countries are parties to the New York Convention as well as the ICSID Convention. So no clear winner here. In terms of confidentiality of arbitrations, it's interesting to note that in France, as far as domestic arbitrations are concerned, arbitration is confidential unless otherwise agreed between the parties. So this confidentiality obligation extends to the name of the parties, to the name of the arbitrators, as well as the parties, the arbitral institution, the legal counsels, and the SITs. With respect to international arbitration, no French legal rule provides for a general obligation to confidentiality for international arbitration. Therefore, the parties must enter into a confidentiality agreement or provide for confidentiality in the arbitration agreement, or choose an institution which rules expressly set out that arbitral proceedings are confidential. So in any case, the French Civil Procedural Code provides that members of the arbitral tribunal must keep their deliberations secret, be it in domestic or international arbitrations. And it's quite interesting when you look at the English system, because there is no express provision for confidentiality in the Act, in the Arbitration Act. However, English law generally recognizes the confidentiality of arbitral proceedings, subject to limited exceptions. So, for example, documents used in arbitration proceedings may be disclosed when ordered by the court, or in cases where such disclosure is necessary for a party to establish or protect his or her legal rights. In the report established by the Law Commission I just mentioned before, the Commission proposed that the Act should not codify English law on confidentiality in arbitration, concluded that it is an area best left to be addressed by the courts. And this is for two reasons. The first is that arbitration is used in a variety of instances, and there is a trend towards transparency in some types of arbitration, such as the investor-state disputes that I mentioned, which usually are ICSID arbitrations. And also the second reason is that existing case law and confidentiality is still evolving and not yet ready to be codified, according to the Law Commission. So no change here in the future. And therefore, again, for the UK system, if the parties want to have confidentiality, they must be sure that they have entered into a confidentiality agreement, or provided for confidentiality in the arbitration agreement, or chosen an arbitration which rules expressly provide for confidentiality of the proceedings. So on this point, I would think that French rules are actually more protective for the parties in terms of confidentiality. Because, hey, let's be honest, another reason why parties would select arbitration is for the confidentiality. So, yeah, it seems to me that the French rules are here more protective for the requirement of confidentiality from the parties. So what about another key feature, which is the ability to hold meetings and or hold hearings outside of a seat and or remotely? I mean, of course, in the aftermath of COVID, I'm sure know that now many more meetings that used to be conducted in persons are now conducted online through Zoom or Microsoft Teams. It's the same with hearings, you know, in IP institutions such as the EPO, etc. And can this trend continue? Okay, before it was taken as a case of force majeure because of the pandemic, but now, hey, everybody finds it way more convenient and also cost saving. So is it okay to still go on, even though its force majeure aspect has now receded? Well, if with respect to the ability to hold meetings or hearings outside of a seat or remotely, nothing prevents them from being held under French law. So for domestic arbitrations and international arbitrations, proceedings are governed by the rules set out in the arbitration agreement itself, or by the institutional rules that the arbitration agreement refers to, but they have to be conducted in accordance with the essential procedural principles of French law. So in particular, due process, adversarial proceedings, so le respect du principe du contradictoire, as we say in French, the right to be heard and to present defense, etc., etc. So as long as these essential procedural proceedings principles of French law are complied with, it's okay to actually have the hearings and meetings outside of a seat or remotely under French law. And in relation to the English system, well, under the Act, the parties are free to hold meetings and or hearings outside the seat. This also applies to remote hearings and meetings. So it's really flexible under English law. Cool. So they seem to be on a par on this flexibility in relation to remote hearings. Then another key feature is the ability to claim costs incurred for the arbitration as well as interests. Well, so arbitrators may award interest on any monetary claim, which will be added to the principal upon enforcement in France. So under the French Civil Procedural Code, interest at the French statutory rate will automatically apply and be added to the principal in any rate when the enforcement of an international award is sought in France, unless moratory interests have already been granted under the arbitral award. So there is no legal provision limiting the jurisdiction of the arbitral tribunal to hand down a decision on costs incurred in the arbitration, including counsel and experts' legal fees. So therefore, the parties may claim before the arbitral tribunal for costs included in the scope of the arbitration. In England and Wales, an arbitral tribunal also has the power to award interests, simple or compound, as it considers appropriate, subject only to the freedom of parties to exclude or limit this power. And similarly, the successful party will be allowed to claim a reasonable amount in respect of all costs reasonably incurred. So there might be a pre-dispute agreement that where the parties have decided on the allocation of costs, but such pre-dispute agreement cannot say that only one party must pay the cost of the arbitration regardless of the outcome. That would be a null and void pre-dispute agreement. So to summarize, in France as well as in England and Wales, it is possible to claim for reasonable costs as well as interests, and like one would do in litigation with the courts. So now let's have a look at another key feature of these two jurisdictional systems for arbitration, which is the statute of limitation for civil claims. So here, England and Wales has the upper hand because the UK Limitation Act 1980 provides that actions in contract must generally be brought within 6 years, from the time when the cause of action arose, so the date of the breach of contract. While in France, actually, the French Civil Code provides that the default statute of limitations period applicable to civil action is 5 years from the day on which claimant learned or should have learned about the facts enabling him or her to exercise their rights. So in contractual matters considered as such, 5-year period starts to run from the date of occurrence of a damage. 6 years in the UK, 5 years in France. I'd say that the statute of limitations is better for the party in England and Wales. Another key feature is the requirement to retain counsel. Well, in both jurisdictions, there is no formal requirement to retain local counsel for the arbitration itself. However, should the need arise to request a state judge to decide on certain arbitration-related matters, such as the constitution of the arbitral tribunal that I mentioned before, or emergency injunctive relief, or even to enforce arbitral awards in France or in England and Wales, then retaining local counsel is necessary. Okay, so on this requirement to retain counsel, both France and England and Wales are on a par, and as flexible, they are both quite flexible on that. So what about the availability of ex parte pre-arbitration interim measures? So in certain instances in arbitrations, some urgent decisions need to be taken in order to stop a situation, like stop some situation to occur dead in its tracks, because the consequences of such situation are really detrimental to one party or sometimes both parties and to the outcome of the arbitration. So let me take, for example, let me take an example. Well, if one party is has got an account and in France or in England and Wales, and this party, because it has a view that there's going to be an arbitration and doesn't want to have to pay potentially any damages to the other party, so this party starts to clear the account located at the seat of the arbitration and move the funds elsewhere in the world. Well, an ex parte interim measure could be taken pre-arbitration by the opposite party to actually freeze the assets in this account. This is an example of an interim measure, pre-arbitration, which could be taken ex parte. So in France, well, the French Civil Procedural Code, which applies in this particular instance to both domestic and international arbitration, provides that the existence of an arbitration agreement does not prevent a party from seeking pre-arbitration interim or conservatory measures before a French state court, as long as the arbitral tribunal has not been appointed. Such measures can be ordered to gather evidence before commencement of the arbitral proceedings. A party who seeks other interim or provisional measures, such as freezing order, as I just mentioned, mesures conservatoires in French, or constitution of escrow accounts reserves, séquestre. So this is where you would actually put the money into an escrow agreement, waiting for the outcome of the arbitration, shall have to demonstrate urgency. In England and Wales, pre-arbitration interim measures are also available and will be granted ex parte, so without notice, in limited but appropriate cases. These are usually for urgent situations where a delay may prejudice the right of the party seeking the interim measure. However, they are subject to a subsequent inter partes on notice hearing to determine whether the interim measure should remain in place or stopped. And the grant of such interim measures is limited to situations where the arbitral tribunal or institution holding those powers either has no power or is unable for the time being to act effectively. It is not uncommon for the English courts to grant such interim measures. So on the ex parte pre-arbitration interim measures, both France and England and Wales have an appropriate system for the parties to be able to hold on to the other party's assets pending the outcome of the arbitration. And what about enforcement of arbitral awards? Well, an international arbitral award can only be enforced in France if it is rendered effective by an enforcement order called exequatur. So this procedure is non-adversarial and only allows the French judge limited control. Indeed, the judge is solely requested to verify if the award whose enforcement is sought does exist, and whether it is not manifestly contrary to the French definition of international public policy. The cases where French judges refuse to grant an exequatur are very rare. So as soon as you've got your exequatur decision, then you can enforce the award in France. In England and Wales, an application for leave to enforce an award should be made in an arbitration claim form pursuant to the UK's civil procedure rules. And the arbitration claim form should be supported by an affidavit or a witness statement containing the information specified in the CPR, and also some exhibit originals or copies of the arbitration award and agreement need to be attached to this application. Originals and or duly certified copies of these documents must be submitted if the award is a New York Convention award. And so it's also possible to enforce, of course, arbitral awards in England. It seems to be a bit convoluted, to be fairly honest. Like there are plenty of forms in England and Wales, and you need to, attach plenty of things. I mean, I'm sure, when you do it day in and day out, eventually becomes easy. But it seems to me that the French system is a bit more streamlined and efficient on this one, to be honest. So in relation to the grounds for annulment of arbitral awards, and this is a very important key feature, because I think that the dreaded thought of any party to an arbitration is to have an arbitral award in which we have a winning party annulled and cancelled. This is always, I'd say this is really the Achilles heel of arbitration. The fact that sometimes arbitral awards are successfully challenged, and then annulled. So what are the grounds for annulment of arbitral awards in France? So there are no additional grounds for the annulment of international awards to those based on the criteria for the recognition and enforcement of awards under the New York Convention in the French system. On the contrary, French law is more liberal than the New York Convention, as the annulment of the award at the seat of arbitration is not ground for refusing its enforcement or recognition in France. Unbelievable. Yet, the French courts would agree the enforcement of an award, even if it's been successfully challenged at the seat of arbitration. In domestic arbitration, as an additional condition, the award must be signed and state the reasons for the decisions therein, its date, the names of the arbitrator, and it must be adopted by a majority vote if the tribunal consists of more than one arbitrator. Anyway, under the French Civil Procedural Code, neither an action for annulment against an award nor an appeal against an order granting exequatur automatically suspends the enforcement proceedings. However, a party may request suspension or adaptation of enforcement by filing a petition with the first president of the Court of Appeal or the judge in charge of managing the proceedings, the juge conseiller de la mise en état, once such judge is appointed by the Court of Appeal. In order to succeed, the applicant must demonstrate that enforcement is likely to lead to manifestly excessive consequences, which means that the enforcement can lead to, for example, the debtor's insolvency or a serious risk of non-recovery of the funds in case the award is annulled and or the order granting executor is reversed. So really interestingly, under the French system, even if there is an action for annulment going on against an award, this is not going to automatically suspend the enforcement proceedings. In the UK, another important point about France, contrary to the vast majority of other jurisdictions, the annulment of an award at the seat of arbitration is neither a ground nor a significant factor to prevent such award from being recognized and enforced in France. So French arbitration law consists that the award is not attached to the seat of arbitration, but rather forms part of an arbitral legal order distinct from state jurisdiction's legal orders, and that its annulment at the seat has no impact on its validity. This is a very, very forward-thinking and also independent approach. And indeed, England and Wales does not do that. With respect to grounds for annulment of awards additional to those based on the criteria for recognition of enforcement of awards under the New York Convention, the Arbitration Act, allows the courts to annul an award where it has been successfully appealed on a point of law arising from the tribunal's award, and only where the court is satisfied that it would be inappropriate to remit the matters in question to the tribunal for reconsideration. And this point of law in England and Wales is limited to only questions of law of England and Wales or Northern Ireland. So a party can therefore only appeal where the law of England and Wales and Northern Ireland was the law applicable to the merits of the dispute. Annulment proceedings do not typically suspend enforcement proceedings, also in England and Wales. The English courts do have the power to adjourn an enforcement action where there is an ongoing annulment proceeding at the seat, but this is not automatic. As a condition of adjournment, English courts may impose an order for security on the party seeking adjournment. So having said that, though, English courts will generally abide by a decision on annulment made by the supervisory court at the seat of arbitration. So it's a very different approach than the French one that I discussed before. As such, English courts will usually refuse enforcement of an arbitral award that has been annulled at the seat. However, in limited situations, English courts may depart from this approach, for example, where the foreign court's set-aside decision was so extreme and incorrect as to be open to that foreign court acting in good faith. This indicates that there is a very high hurdle that must be met by a party seeking the enforcement of an award which has been annulled by the court of the seat. So to conclude, while both France and England and Wales seem to have established sturdy and strong legal frameworks to organize arbitral proceedings and empower arbitrators to hand down the arbitral awards, France seems to have the upper hand, really, in terms of enforcing awards, arbitral awards, no matter what, on its soil, and also in terms of confidentiality I mentioned. Indeed, the UK seems more squeamish in case foreign awards have been annulled at the seat of arbitration. And one good thing for the UK, which is best than in France, is the statute of limitations for breaches of contract. Yeah, 6 years instead of 5 in France. So this is where the England and Wales wins. But for the rest, I think in terms of enforcement of the awards, it seems that France is a more pro-arbitration system. So it is possible that the upcoming reform of the Arbitration Act will reinforce the ability of parties to enforce arbitral awards in England and Wales once the findings of the Law Commission set out in the report are put in place. So let's watch the space. In the near future. Let's see whether England and Wales manages to improve its system and its independence as well in relation to enforcing arbitration awards, even those which have been successfully challenged at the seat of the arbitration. And yeah, thank you so much for being here, for listening to this talk. It's been lovely to join you all. If you want to read as I said, a recent version of this on this topic, on who has the upper hand between France and England and Wales for arbitration matters, do have a look at our publications on our websites, crefovi.com and crefovi.fr. It's been lovely. Thank you so much. Bye now.